So you have decided to buy a house that is part of an estate going through probate, and the sale requires court confirmation. Over the next few minutes, I will explain everything you need to know before submitting an offer. And stay tuned until the end to get the answer to the most common question I get when it comes to buying probates. Hi, this is Matias Baker Masucci, your trusted Los Angeles realtor. When someone passes away, any property they own in their name, valued over a certain amount, must go through probate. That includes virtually any real estate they may own in Los Angeles County. Keep in mind that unless the property is in a trust or held by an entity, it must go through probate whether a will exists or not. Now, in most cases, the court is able to confirm the executor or appoint an administrator with full authority to settle the estate. The code refers to these individuals as personal representatives. But in certain circumstances, an administrator is appointed with limited authority. When you have limited authority, you must get court approval before taking certain actions, such as selling real estate. Court approval means a confirmation hearing and possible overbidding. So what does that mean to you, the buyer? In order for the personal representative to file a, ready for it, a report of sale and petition for order confirming sale of real property, now that's a mouthful, your offer must meet certain conditions. Some of these conditions impact you directly. The sale cannot be contingent or have any conditions, and the customary deposit in Los Angeles County is 10% of the purchase price. There are exceptions, but that's not important right now. So what are the most common contingencies in a real estate sales contract? Satisfactory property conditions, so that's inspections, document review, appraisal contingency, and loan contingency. On most regular sales and on some probates, you can work your way through these contingencies during the escrow process. But this is not always the case. Some sellers and their representatives work a little bit differently. All potential buyers are encouraged to complete all their investigations prior to submitting an offer and submit a non-contingent offer. A non-contingent offer means an offer that is not dependent on any contingencies apart from confirmation of the sale by a probate judge. A financing contingency, aka the ability of the buyer to obtain a loan, cannot be a contingency of the sale. Same applies to an appraisal contingency. The idea is that once you promise to buy the property and you deliver your 10% deposit, your commitment is final. Now, speaking of the 10% deposit, some administrators and their representatives are okay with the money going directly to escrow. But another common way is to obtain the funds in the form of a cashier's check. So you completed all your investigations, submitted a non-contingent offer, got it accepted, and gave the seller's agent a 10% deposit in the form of a cashier's check made payable to the estate. What happens next? The administrator, or in most cases an attorney on their behalf, files a report of sale and petition for order confirming sale of real property, requesting a confirmation hearing. In Los Angeles County right now, it takes about 30 days from the date the petition is filed to the hearing date. Timing is dependent on how busy the courts are, but for the most part, believe it or not, the probate courts in Los Angeles are pretty efficient. All confirmation hearings in Los Angeles County take place at the Stanley Moss Courthouse on Hill Street in downtown Los Angeles, Monday through Friday, starting at 8:30 a.m. Is that it? Can you just sit back and relax and wait for the agent to deliver the keys? Not so fast. Enter California Probate Code Article 6, Section 10311. If a written offer to purchase the real property is made to the court at the hearing on the petition for confirmation of the sale, the court shall accept the offer and confirm the sale to the offeror if all of the following conditions are satisfied. Condition number 1. The offer is for an amount at least 10% more on the first $10,000 of the original bid and 5% more of the amount of the original bid in excess of $10,000. Condition number 2, the offer is made by a responsible person. And condition number 3, the offer complies with all provisions of law. Now, what does that mean? Okay, it means that anyone can show up in court, and if they can successfully demonstrate they meet this criteria, they can place a bid and purchase the property. However, the original offeror, remember that's you, also has a right to increase their bid. The easiest way to calculate the first overbid amount, albeit not exactly as reflected in the law, is 5% plus $500 of the original offer amount. Let me give you an example. If the original offer amount is $1 million, the first overbid amount will be $1,050,500. When it comes to the next bids, in most cases, the judge plays the role of auctioneer and decides the bid amount in court right then and there. Once the sale is confirmed and the order is delivered, according to the standard California Association of Realtors contract, you have 10 days to complete the sale from when the order is received. However, the timing is a bit different. That is because the judge has to sign the order and it must be delivered to the escrow and the title company. This process takes 3 to 4 weeks. When the order is in, the transfer can be made, and congratulations, you are now the new owner. Now, you may be just as confused as you were when you started watching this video. So let me leave you with some very important word of advice. Work with an agent who is familiar with the process. And now, before I let you go, I will leave you with some very important word of advice. This is the question that people ask me most of the times, which is, what are the chances that someone shows up in court to overbid my offer? The answer is relatively simple. It all depends on the amount of the original offer. If the amount is too low relative to the property's actual market value, someone should show up. That's why the probate code is there, to protect those who can no longer speak for themselves. Now, don't forget that this video was made for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. Thank you for sticking around until the end. My name is Matias Baker Masucci, and if you find this content useful, please like, subscribe, and help me spread the word. If I don't hear from you sooner, I will see you in the next video. Thank you and goodbye.